The opposition, Your Honor, was that you seek summons. And the nature of the summons was not indicated to you. That is to say, Your Honor, therefore the application for you to deny bail must be read in light of that mischief. That other than pursuing public interests as dictated by Section 4 and 5 of the ODP Act, the ODPP is equally pursuing other ulterior motives that are politically actuated.
And our apologies. Passing to the elections, Your Honor, to direct the focus on the chargeship that the council has anything. Pass on the elections.
Minute and recording is start.
The direction.
Minute, I'll give you the directions.
The director will focus on the chargeships and the issues related to bail. The colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we will ask him to take the stand on the other side and we will read the evidence. So let me speak on bail. And that's what this person. We just want to give the motive to anybody unless they are willing to take the law.
Your response, Mr. Zero.
Your Honor, my response is contained in the affidavit filed by the ODPP. But it's not surprising, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what I earlier submitted. If I was to proceed in response to the substantive application,
Minute. Must give direction in the objection. I remind that once more, I belong to the law on bond and bail, to avoid instances which may persuade me to request the fact having evidence from your end.
I am well
Which will render you in a very awkward position.
I am well Your Honor, the affidavit contains mere speculations. There is no affirmation in the affidavit.
After every sentence,
and there is no affirmation in the affidavit that is linked to the charge sheet before you. The affirmations in the affidavits have no nexus with the charges before you. These are matters that are happening in other spaces, which none of us, neither the prosecution, nor the defense, nor the court, are privy to. That is to say, that to deny the accused person bail on account of supposed investigations would be tantamount or will amount to violating his constitutional rights. And most importantly, the right to presumption of innocence and the right to liberty. The argument here that the intended witnesses are subordinates to the governor, the accused person, really is not contained anywhere in the affidavit. And the same does not amount to a compelling reason. And so to say, the argument that vehicles were destroyed by his agents when there is clear lack of evidence linking the so-called agency the accused person, again is speculative, has no probative value of whatsoever nature, the same is not empirical, and there is no nexus between that environment with the affidavits and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, is that the office of the ODPP, which is fully funded with the taxpayers' money, had no courtesy of proving the ownership of these vehicles. The producer of the so-called annexures, for instance, we will not tell you who is the registered owner of KBU 734Y. Again, from the same annexure, we will not tell who is the registered owner of KCH 046T. It will not tell you who is the registered owner of KAE 7-8F. And you're being invited to deny bail on that ground. Registration of motor vehicles is a legal process. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, respectful to the process and the proceedings, and holding the values of the Constitution of accountability and transparency, they would have consulted the NTSA. I went to just as a pen off and invite my other friends to draw your attention to the charge once again that there is no charge that the government is facing that is linked to its office. There is no way in the charge sheet that says that the governor abused his office. There is no way in the charge sheet where there is a charge of conflict of interests. That is therefore to say, in the absence of such kind of overcharge, in the absence of evidence, the argument and the affirmance by the prosecution is not being believed. I was perplexed, Your Honor, in summary, when I heard my own friend Mr. David invite you to look at Article 50 in isolation of Article 25 in light again of Section 8 of the Magistrates Court Act. He invited you to hold that the only jurisdiction you have in that respect relates only to Section Article 25A and B. Curiously enough, and in the attempt to persuade you, he believes the presumption of innocence and a fair trial from Article 25. He tells you that the Your Honor, that the presumption of innocence.
I need to stop.
Or finish on my job. So we will cast it. He tells you that the right to presumption of innocence under Article 50, as protected by Article 25, can be limited under Article 24. That's a fallacy. It's a fallacy, it's a misconception, it's committing injustice and defiling our Constitution. What is compelling? If you look at the Lawfulness dictionary, it will give you as to what is deemed to be compelling. That thing must be a strong issue, it must be convincing, it must be legally justifiable. It must be, or it must have the effect of compromising the integrity of the proceedings. None such affirmance has been pleaded. No evidence produced. No law quoted. No case law referred to. And as such, Your Honor, the granting of bail to our client will not prejudice, will not compromise the integrity of the proceedings, will not affect the so-called pending investigations. Your Honor, be minded of Article 24 and be minded of the test therein. When can a right be limited? A right can only be limited if it is just reasonably justifiable in a democratic and an open society. I invite Mr. Jerry to guide us on who next. Thank you, Your Honor.
How long more?
We won't take more than 10 minutes.
10 minutes.
I also give you a case law.
So how long are you?
10 minutes.
10 minutes.
Another
Another unexpected.
This is they'll be very brief. We have 4 more, but they'll be very brief. I'll manage the situation.
Always remember, the court has also business. So if we submit here the whole day, we understand the application, right?
We understand.
So we cannot submit the whole day and expect magic. We should be reasonable, and they say, for a wise man, 1 sentence is enough. You don't need to give 100 sentences in circumstances where you can give 1 sentence. I think that broad guidance serves us right?
Yes.
So we don't need to talk, all of us. In fact, I expected Mr. Njeri to ground this. There is no need of all of us.
We will be very brief.
We are guided.
So this is Mr. Chesa. Chesa, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue with the manner of arrest. Which manner violated Article 25A of the Constitution and Section 8 of the Magistrates Court Act gives the authority to inquire into these violations. What this court gave the EACC was search warrants, not search warrants. Which they abused by literally breaking into the accused person's residence in Kitale and Nairobi, bundling him into a police vehicle and detaining him at the Integrity Center offices. We hold that the arrest was barbaric, unlawful, and an affront to the dignity of the accused person. Your Honor, to deny bail, the High Court in Danson Mgunya and another. This is the Mombasa criminal case number 26 of 2008. The High Court said the prosecution must provide cogent, the term is cogent evidence and not mere allegations. You have been told through the affidavit of Mr. Rono, he keeps referring to some ghost creatures
called agents of the respondent. Agents of the respondent attacked EACC vehicles. Agents of the respondent shouted at Integrity Center, and that's a very serious threat. They have not drawn the matrix to link Governor Natembeya to the so-called agents. Was it Governor Natembeya's wife? Were they governor's children? Were they his staff? There is no such evidence placed before you. And those who amount to rumors, and this court must not listen to them. The accused person, Your Honor, is a decorated career civil servant. He is the governor, government of Trans Nzoia County. He is a deputy party leader of one of the most progressive parties. In all this, he is not a lonely man. At the time, the so-called ghost agents were shouting at the Integrity Center buildings. The governor had been locked up in the police cells. He had no access to his phones. He was only allowed one advocate, Mr. Simiyu. The rest of us were locked out. Jero was asked to get clearance for net escape. Jero was asked for clearance for net escape to access his client. At what stage the governor planned with the so-called agents to do the unimaginable things that the state is supporting? In Nairobi miscellaneous criminal application number 351 of 2016, in Nairobi miscellaneous application number 351 of 2016, the court said that the seriousness of the offense per se is not a ground to deny bail. At the time of arrest, 2 more minutes, Your Honor.
I just
2 more minutes, if this court allows. But just have 2 case laws, and we can do that 1 case law.
if we can stick to the directions of the courts.
I understand you.
You've already done more than 10 minutes. I gave you 5. I closed my eye to say you're finishing on the 6th minute.
Okay, just one more. In that case, you've recorded that the seriousness of
I repeat, one word is enough.
Lastly,
I don't know why we get this temptation, that the more I speak, is the more I persuade. Sometimes it's counterproductive. Can I bring it to your attention?
yes.
Sometimes it is counterproductive.
This last one, R versus Richard David Alden. R versus Richard David Alden.
Richard.
David Alden. The High Court at Nairobi. Criminal case number 48 of 2016.
Second case. Just list them. I will look at that.
Very well. I think that was the last case, and that the prosecution must demonstrate actual witness interference, not mere allegations.
Straight.
Witness interference. Employees of the county government are retained by county public service, county service board, and not the governor. Therefore, there is no relationship between the governor and the employees of the county government, save for CECs who are merely policy makers. That is all.
Your Honor, with your permission, Mr. Simi was the accused person in the ACC. He only say one word. He follow your guidance. Your Honor. Mr. Simi. Your Honor, take 2 minutes. And I'm addressing
Proceed, Mr. Simi.
Thank you, Your Honor. Your Honor, number one, I just want to write on what Mr. Echesa has said. The accused person did not have capacity to direct. Did not have capacity to direct third parties to commit acts of vandalism. Your Honor, I have an inventory.
Slower. Don't need your 2 minutes. Let's take it slow.
Your Honor, I'm worried about my 2 minutes. Your Honor, I do have an inventory. Yes, Your Honor, which will demonstrate to you that indeed, as at 6:30 a.m. yesterday, the accused person had lost his 2 phones. And of course, he was in custody. So he could not speak to third parties. So, Your Honor, the averments in the affidavits by Mr. Robert Rono is certainly not accurate. Number 2, Your Honor, the place where they went to conduct searches. Your Honor, I want to refer to the affidavit of Mr. Rono at paragraph 3, where Mr. Rono said that among other places, they went to accuse persons Kitale Milimani residents. That is repeated at paragraph 4 and paragraph 5 and paragraph 6 of the affidavit. Now, Your Honor, juxtapose that to the order. The order that they received to search the accused's premises had the following residences. 1 is Rongai residence in Nairobi. 2 is a residence in a place called Kipomet.
Come again.
First is
Second
is a place called Kipomet. Third is Nairobi residence in Kileleshwa. Okay. that, Your Honor, when you turn to the affidavit, and of course they are using paragraph 6 particularly, to seek to deny the accused person bail, they are saying that the motor vehicles that are said to have been vandalized were vandalized when they were searching his Italian residence. Your Honor, looking at the order, which Your Honor you can have a look at, the Italian residence is not captured. It's not there. And therefore, Your Honor, we are appealing to you that the evidence that has been annexed to the affidavit is illegally obtained. And we are not very sure that the pictures that are said to be connected to the accused persons are genuine. And Your Honor, to cut that, I would want to refer you to the Evidence Act, Section 106, Capital B.
I refer you to something. Are you ready to listen?
Are you?
Honest to records.
Thank you.
No, I'll try 3 minutes at max, and you stop your time.
Be sure it is 3 minutes.
Stop there now. The first point, Your Honor, is just to raise point.
Now, I expect you start with what you wanted to raise.
Yes, that's what I'm addressing. Your Section 106 about the B of the Evidence Act is very clear in the manner in which electronic evidence is used. There is no certificate of electronic evidence annexing those pictorials. By dint of that section alone, there is no evidence in support of the bare allegations in the affidavit. There is no basis to even advance now any compelling reason.
Slow. Let me remind you. There are allegations contained in the
And in the absence of the electronic certificate, the annexures are inadmissible, and the court should expand them. In their absence, there is no evidence brought to court to support the opposition to bail. Finally, Your Honor, you are told that this court cannot interpret the Constitution. Section 3 of the Judicature Act lists the sources of law in Kenya that this court is called upon to apply. This court can apply the Constitution, including the Bill of Rights. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply it in the ordinary course of the court's duty. We are not asking for interpretation. Last point. Everything remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. The subject of the proceedings is now a warden of the courts, not a warden of the state. Bail and bond for pre-hearing detention should never be used as a basis to punish an accused person who is still presumed to be innocent. And I urge Your Honor to so consider this accused person as its warden that will attend to court as and when this court requires it. Thank you.
Jerry, your last soldier. Is it your last or
Listen and then we are talking about Amino.
Dr. Amino?
Thank you, Honor. I'll take only 2 minutes.
Professor, you said you were taking 2 minutes.
2.5 minutes. I'm here before you to demonstrate that what I did recently in my second PhD in criminal justice should be put in a maiden opening, and you are the first that I'm hearing before, so I'm very privileged. Secondly, I would like also to thank my former teacher, Sunil. I think he taught me very well, and that's why I've been proceeding all. Now, the point that I want to make is just 1 or 2. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ESCC and their mandate. I would like to apply what we call strict scrutiny. Strict scrutiny test. Law, whereby the government raises its own legitimate expectation to validate it is incompetency. Incompetency is aligned to rights protected by the Constitution.
Come again?
Incompetency is aligned to rights which are fundamental and protected by the Constitution. If that was the case, then that law must be narrowly, and I mean narrowly tailored to serve a compelling interest. What is a compelling interest? I'll not go into that issue because my senior counsels before me have already spoken about that. How do we look into the classification of what the state has alleged? Classification, looking at the time of the search, the time of arrest, the time taken to drive, the accused, the miles involved in that journey, the manner in which the accused was transported, where the accused slept, presumably in this case a common floor, and how the accused was arraigned in court. Lastly, Your Honor, I may not understand, and please let the court make me understand, whether the arresting officer is the investigating officer and the judge and is an evidence provider, provision of evidence through affidavit, which even if mandated by statute, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances in court, then there is high potency of illiteracy in the judicial, in the government executive system. I rest my case. Thank you.
Professor, are you sure you want that to go to record?
I think it should, because I can substitute it.
Literacy in respect to...
Your Honor, what I mean by literacy is not literally academic, schooling, but experience. And if we are to do what we call discoveries in law, the kind of affidavit you have seen here raises issues that can only be raised on discovery.
Your have admitted yourself. Thank
Thank
you. Thank you. Daktari, how long? I'm not even sure whether I will fix time for you.
I will be extremely brief, except I'm asking for one indulgence.
Yes.
I have my own friend in Ethiopia. I always appear with him in the cases. He has got only one word he wants to tell you. Only one word.
Very well.
One word will take maybe 1 minute or less.
Very well. Continue.
First, please look at the charge sheet. Point 1, the persons named there are 2. Particulars refer to 1. It is impossible to tell which one will be, except for the use of the word government. So we don't know whether the fuller is not for government or the Indian is for government. The second point related to that is particulars in the charge sheet under the law. And I take that is something that the court knows how to do that, right, and understand. Those particulars which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest are not been indicated. So without the indication, that what you call the seriousness of compelling evidence is not there. If you look, sorry, we have that code, that was speaking this. If you look at count 2, the same problem of lack of particulars. So that there is no evidence that demonstrates the nexus between Mr. Natembeya and the brother. And the third count relates to the manual we're going to talk about. Lastly, and this is about the allegation of money cards of the government. Something I was told when I was being talked to the grandparents when I was much younger. We were told monkey see, monkey do. When the government itself gets court orders, citizens have no reason to monkey see, monkey do. When government routinely violates court orders, it is impossible for citizens to trust it. So nobody will trust that they are doing anything in the country. So the citizens are taking enough of the government. And very lastly, I do recall off the top of my head, the governor of Istanbul, who was charged with the blood of support. The court ordered that he should not go to the county government. So this issue of interference with the subordinates, if there are any, but my colleague just every does not say the court has authority and discretion to give conditions that will ensure that the proceedings of this court are currently paid.
Thank you very much. Your Honor, I was very the first point I would like to make to you, respectfully, Your Honor, is that several counsels or advocates have spoken. They have made submissions. I would respectfully argue that before you write a ruling, identical ruling, it is very necessary to guide this nation. You release the governor and you tell the audience that a written ruling will be delivered. Your Honor, this has always been done by the Court of Appeal, by the High Court. This has always been done by the Court of Appeal.
This one?
Giving reasons later
Yes.
has always been done by the Court of Appeal, the High Court, and recently even by the Supreme Court. So I ask you very respectfully that before you rise this morning, you make an order that the governor is released forthwith, and you deliver the body letter. I also ask you very, very respectfully, Your Honor, that we give him a free fall. The governor will go nowhere. We all know it. He lives in this country. He has rendered sterling services to the nation, and there's no way he can leave Kenya for another country. Give him a free fall. And you will also be educating certain people and certain people that the criminal law of the country must not be abused at all.
Slower, Dr. slower.
Your Honor, I'm saying to you respectfully that you make an order before you rise.
Sorry, that I scored, and it's okay.
That the governor should be released on a free bond, and you will give your reasons smart letter. Your Honor, permit me to continue.
Continue.
Your Honor, I'm a child born in the colonial days.
You're a child?
Born in the colonial days.
Colonial days.
I'm a child who received education in colonial institutions. I'm a child who read colonial literature of sociology, anthropology, philosophy, when you had terms like the African mind, how the African things and so on from the colonial days. There's one thing I can make you very clear. The criminal law of Kenya has always been abused. It has always been abused by those in power. It was abused during the colonial days. It was abused during the stage of the Kenyatta state. It was abused considerably during Moi's state. The only president that can put in a word in his favor is Moi. The criminal law was not abused during the Prosecution.
I think the statement is home, Dr. The statement is home.
Oh, thank you very much, Your Honor. Now, Your Honor, permit me to go a little bit further. It is now being abused by the executive, by agents of the state. They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. And Your Honor, I'm urging you very respectfully that you can only get out of this quagmire with boldness from the petition. Our judges have to be bold. Our magistrates have to be bold and state very clearly that the country will not be governed the way it is being governed at the moment. Your Honor, we live in this country. Every day I'm reading the Senate, I'm reading the Nation, I'm reading the Star, and I go even further to read any other newspapers outside this country. Clearly, Your Honor, what is emerging at the moment, that unless we arrest the situation, nobody will have confidence in the country. The country could easily be classified as a banana republic. I filed a case recently, Your Honor, in court, the usual process, that we should refer certain matters now to the ICC.
No, Your Honor.
That it should require certain matters of disappearances to the ICC. Let the International Criminal Court come in and see what it can do. Then we can come.
If we can deal with Mr. Natembeya first.
Yes. Your Honor, what is the judge? Can someone give me the judge? Your Honor, the judge you are given here, one can even pass in class. The first comes. The governor is supposed to have corruptly received the sum of shillings 1,127,900,000 shillings. You're not being told that they took away billions of shillings. 1,127,900,000 shillings. Anybody with a critical mind like of John Camino can see that this is dishonest. It's nonsense. That you're bringing a governor of the state to the country because of that amount of money. That's on the first page. On the second page, 2,124,668. Hey, what is that? I'm from governor. 2,124,668. Sadly, Your Honor, the amount involved is 2,680,461. This is the way manual of the Muslim. Your Honor, the criminal law is being abused. During the days of we will make one point clear. A constitution has been meaningful. It must develop something called consensus. A constitution is meaningful. It must develop in some cases something called consensus. You would expect that a charge against a governor of the country, the director of public prosecution, would lead the entire file to satisfy himself that indeed a case has been made out before placing such a case before a criminal court. Your Honor, when did the DPPs read the file to satisfy himself that a case has been made out against Mr. There? Having regard to what was being told, was arrested with yesterday morning. When did the DPP read the entire file? And this is what I say in favor of Charles and Johnson. He would read the entire file to satisfy himself that indeed a case has been made out against the government. A governor is no small man. A governor is not a messenger. A governor is a person who is ruling and governing millions of people. It is therefore not surprising that the people in his own area were mad to hear that their governor is being arrested. He's being brought into the country, being taken by the police. It's quite clear the file was not read at all. Your Honor, may I draw your attention to the fact that I shall, if I'm given the opportunity, I shall be conversing in some other quarters that the courts have no jurisdiction to contain the counts that they have to that place people. There's no jurisdiction at all. And I would refer you to Article 181 and Article 182 in the Constitution. If you read Articles 181 and 182, Your Honor, there is no provision that provides that a charge can be prepared against a governor. The way to deal with a governor is to use the impeachment proceedings that have been provided for in the Constitution. A governor cannot be arrested and charged the way things have been done. The director of Prosecution himself, Your Honor, the DPP has no jurisdiction to make or to file charges against the government. So there's lack of jurisdiction. I'm making this point to strengthen my submission on it, that there's no case against the government. Listen, Jonah, one final question, or one final submission the next year. Please don't misunderstand me at all. I've often thought that in a country like Kenya, strictly speaking, you do not have to be bright. You do not have to be bright in the law at all. What is required of a lawyer, what is required of a magistrate or a judicial officer is to be strong and to be courageous. The mighty new face that rise to the occasion and show those who are in power, who are in executive, that your powers can be challenged, that your powers can be reduced by the courts. And it is the courts that are in control of the country and nobody else at all. If we lose the control of the courts of the country, if we lose the power that the courts have, Kenya can easily and very shortly be classified as a banana republic. No wonder that the president of Tanzania said the word that he said about our country. The country has gone up. And we need young people like yourself, who have got power, to see what we can bring up and maintain the concept of rule of law in the country, independent of judicial, and to make sure that we can use the word and we borrow the word of our president, that let the executive keep its own day, not to get into other days. At currently, it is not doing so. Thank you. Asking to yeah. You want to program me say that when the Mahatma, I handled in some other quarters and so on.
Mahatma.
Yes, there is a book here I will be referring to impeachment in the Nigerian presidential system. That's where we have a lot of impeachment for governors and so on. And I will be borrowing words from this book. I'm just putting my learned friends from the prosecution notice that they order for this book.
What is the title?
Order for
I'm taking the title of Impeachment in the Nigerian Constitution. I assure the very learned student that you have come.
I don't have impeachment of governors, Your Honor. And in Nigeria, you will see when members of the executive swearing that they would rather die than have such a governor in power. Yes, some people, I'm sure, are swearing that they would rather die than see Governor Natembeya in power.
Very well. Mr. Njero, I think we are done.
Yes, we are done. So it's
yes.
Our father, with the father, the profession, he has said it all. Okay, the governor, free vote. At the very worst, some affordable cash bill. Let him not stay here an hour longer, so that we don't play in the hands of these tormentors. Let there be no conditions. This man has been elected by his people. He has committed no wrong until the case is proven, if at all. There was not even any affection in that effect. So let's not talk about conditions. In fact, that date, one of these expanded. Let him get his free vote or cash bill, let him leave. Even a street boy here will not miss children up in there. There's nowhere where he will go. We believe. We believe. You know the right thing. We have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law, you understand the law, and even as we are doing all these things, you've appreciated it. I have no doubt that today judgment will have no doubt. No conditions have been sought and shouldn't be behind you. Let man go and serve. He'll have his day in court. Thank you very much.
Sorry, Your Honor, do we have a right to respond?
Of course. Can you hear me? Mr. Owiti, together with you on
I'll just go along. Most
you have
highly.
not specified.
Yes.
Your Honor, start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Amino, as to whether or not this court properly has jurisdiction to entertain these charges. And whether or not the Director of Public Prosecutions had power to institute these charges.
Yes.
And that is related to reference to Article 181 and 182 of the Constitution relating to vacancy in the office of a county governor in Kenya. I believe, I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided for under Section 4 of the Anti-Corruption and Economic Crimes Act. So that's a simple answer. Section 4 of the ASEC. ASEC is a law. Point of law is ASEC. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings against anyone before any court other than a court martial, Article 157, 6A of the Constitution. Allow me to make two corrections. My very good friend, Mr. Degwa, tells the court that there is no nexus between the affidavit and the charges. And if your record confirms what I also heard, that there is no such charge as conflict of interest, which is count number 1. I don't know whether counsel read the charge sheet. Count number 1 is conflict of interest. And not just that. Count number 2. How could he have gotten that wrong? Conflict of interest. And it does not only mislead you on that. He says that the prosecution, on behalf of the prosecution, no law has been pleaded, no evidence has been produced, no case law has been referred to. I refer to Tom Chomley, it's case law in Kenya. I quoted Article 49(1)H. I quoted Section 123A. These are laws in Kenya. The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't get that wrong, tells the court that the areas, the subject of the warrants issued on 18th of June were limited to 3, Kibomet and another one, it's on the record, Your Honor.
Sharia also.
Oh, Mr. Sibiu, I apologize, that's why I was not sure who's in. Your Honor, for those who have not given me a copy of that warrant, it says, and any other part. Let me just read that so that I get it correct, so that I don't mislead the court. warrants you've been referred to, just below the areas listed, there is any other office, business, and residential premises wherever they may be situated within the Republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, was sanctioned by law. But then there's the related question as to whether the warrants issued could also be the basis of an arrest. That is the question asked by my learned friend and teacher, Mr. Echesa. Your Honor, this is a cognizable offense. Mr. Smith taught me this way back in 2011. For cognizable offenses, you don't need a warrant. So the arrest was proper by law. So the arrest was proper. The searches were proper. The defense has attempted to repudiate the charge sheet. Although they have gone around the corners, they're not coming strongly about it. But they seem to be questioning the propriety of the charge sheet, or rather the charges. There was no attempt to invite this court under section 89(5) of the Criminal Procedure Code to reject the charges. Plea was taken. As it is, the charges are proper, including the particulars. And in compliance against with section 214 of the CPC. But there is a smaller issue about the amounts. This is related to the charge as well. That a whole governor should not have been brought before you for amounts about 1 million or 2 million. You know, I agree with Mr. Ochieno that this court may not interpret but can apply. In the application of the constitutional provisions, Article 27, Sub-Article 4 obligates this court to ensure and promote an equal application of the law to everyone. Equal application of the law. Article 27, Sub-Article 4 of the Constitution. Before this court, you know, I've never had the privilege of appearing before you. And I'm sure my colleagues who have here have brought people with cases of soliciting a bribe. Some of them up to 3,000 or 5,000. They are Kenyans as well. So that the amount, the basis of the charge cannot be the basis to question whether or not the charges are proper or whether or not compelling reasons exist. I can confirm to this court that's a factual issue, but I can confirm to the court that the DPP, in fact, ascertained and satisfied himself that there were charges properly on the basis of which he could institute these proceedings before you. Now, in respect of Article 181 and 182 of the Constitution, we are not attempting to impeach the governor. The DPP has no such powers, legally or factually. But more importantly, whether or not denial of bail would amount to removal of a governor has been answered by the Supreme Court of the land in the case of Ferdinand Waititu versus Republic.
You know, he's raising new facts that were not part of our address to the court.
That's a question of law, Senior.
No, it never came up, Your Honor. We perhaps need a very clear ruling on that particular objection, because that never arose in our submissions.
Dr. Aminu raised Article 181 and 182 and said that removal can only be by other parties, not the DPP or this court. That's what I'm answering. And again, because Mr. Ndegwa did not even know that conflict of interest was count one, he may have missed this as well. I withdraw.
If you have withdrawn, I wanted to clarify that I scored me Dr. Minute saying something else.
Yes. It's going to mislead, unfortunately, it's going to mislead the court.
Now that he has withdrawn, there is no need to clarify that point.
So, Your Honor, I found out
scored him differently. Yes. So, now that you withdraw that point, I will not.
Most of like I've also withdrawn the arguments on 181 to I scored it differently. Well, back to the question of bond as I conclude. Page 19 of the Judiciary Bail and Bond Guidelines, at the very bottom in the footnotes, refers to a case of, let's get it, Republic versus John Kahindi and two others, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines. The import of that case, Your Honor, is that the prosecution does not need to avail an affidavit in opposition of bail. Anyone can confirm because the guidelines are available online.
The prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that you make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there is no basis. If we can come without an affidavit, there is still basis. There's also the argument as regards saying that we are not proved. Sorry, Your Honor.
You are now on your 12th minute.
15 minutes and I'm done, Your Honor. I underestimated my abilities. I'm sorry.
You can't admit that. No, your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
Yes, yes.
A minute. Continue, Mr.
Thank you. Your Honor, I was referring to, please help me direct. What did I say last? Thank you.
Last you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate and
that was concluded.
Then I can move to the next point. Your Honor, the other issue as regards bail, as I conclude, is that there is an admission from the defense, at least evidenced by Mr. Echesa and Dr. Haminwa. In Mr. Echesa's words, the first accused is a governor of a county. He is a deputy party leader, and he is not a lonely man. Verbatim, if I got it right. In the words of Dr. Haminwa,
I don't know whether Your Honor will misquoted in my presence, actually in terms of understanding.
You were not sure what you are objecting on. Is it points of law or what you say?
As in, you have quoted my statement here in my presence.
Yes.
You clearly misunderstood it, and you want to go to the next person without clarifying the question.
Sorry, Your Honor, I have not interpreted what Mr. Echesa said. I have quoted it as I captured it. So the court can confirm that he said that the first accused is the governor of a county, is a deputy party leader, and is not a lonely man. I am quoting you verbatim. I may be wrong in my interpretation, but in hearing you, I can't be wrong.
Points of fact, points of law.
I'm coming to the point of law. I'm still quoting you. You cannot be the point of law. I am coming to the point of law. Yes, I'm still quoting you so that I come to the point of law. Dr. Hamura on the other hand says that the people in the first accused area were mad yesterday as a result of his arrest. Those are two admissions as to and thirdly, I am reminded that my very good friend, senior Dr. Harunubi, mentioned that monkey see, monkey do, that the people have seen and are doing. The point of law we are making is that there is a likelihood of interference with witnesses. And that the influence of the first accused is admitted by his counsel on his behalf, and that it is not far-fetched that he would interfere with witnesses and investigations. Your Honor, clause 4.9 sub-clause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. Yes, Your Honor.
You have said you need 30 minutes.
I am done. That is my last point. 4.9 sub-clause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. It doesn't say certainty as proposed by Mr. Lego. If there is a likelihood because of that influence, there is a compelling reason you must deny bail. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouth. And we urge you that we have established compelling reasons to deny the first accused bail. Thank you, Mr. Leon.
One of the colleagues actually Honorable Jeremiah Kioni, Assessor Council, who wished to place him on record.
It's now almost 1. Taking it so far. So I will need a break to do a ruling on the matter. I possibly need almost 1. We take a lunch break. Take a lunch break. Though the issues are going into millions, I will try the best to do it in 1 hour. And Dr. Haminwa encouraged me to deliver decision, give reasons later. Unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by dint of their own procedures. Or for the subordinate courts, that actually can give ground to suspect of my abilities and competence, which I do not wish. So we take a break. We resume at exactly 2 for the ruling.
Much obliged.
Welcome back to Watching Daybreak on this 20th day of May 2025. In studio I have Geoffrey Wandeta, who is the Member of Parliament for Tetu constituency. I also have Kabala Kile, Deputy Chairperson of PLP Party, People's Liberation Party, right? Great. Senator Veronica Maina, nominated Senator of the ADA Party, the governing party, and also Professor Maxwell Miyawa, International Development Law scholar, and also teaches at the Kenya School of Law. Before we dive into the conversation, there's a story that I want us to take a look at, which is about the High Court has suspended the vetting of nominees for IBC chairperson and commissioners that was due next Monday. Justice Lawrence Mugambi issued the orders after lawyers representing petitioners Calvin Roy Omondi and Boniface Mwangi warned of the risk that the National Assembly may proceed to vet and approve the nominees in the absence of orders. The orders will remain in place until the 29th of May. Attorney General Dorcas Ruo, who filed a preliminary objection on the case, says the court lacks jurisdiction to hear the matter. IBC nominees face another case filed by civil society outfit Operation Linda Jameen, who argued that the nominations are made without the necessary political consultation. The case is due for further direction on the 11th of June after petitioners serve respondents.